Okay. What happens if the decedent died without a will?
It's not uncommon that clients, despite our best efforts and advice, will not ever create a will, or they'll create a will that becomes invalid for a variety of reasons. And if one dies without a valid will, we call that you've died intestate, meaning you did not have a will. Well, California will give you a will. They will tell you exactly what will happen to your property. They will tell you who's in line to be appointed the personal representative, what we call an administrator of that estate. And the administrator will do the same things that an executor under a will do. Uh-huh. But ultimately, the heirs are the ones who will inherit that estate. There's no variation, no matter what the decedent may have orally told somebody what he or she wanted. It's going to go to California's heirs, which in many cases may be the same people, but not in all cases.
Mm-hmm. Okay. Now, let's say I'm nominated as an executor. Do I have to accept? And what should I think about before accepting?
That's a good question, Mike. When one creates a will and nominates an executor, we assume that that person will serve. When the time comes, when a death does occur, that named individual may not be physically able to do it, or may not have the time availability to do it, or may simply just not want to do it for a variety of reasons. So when you're named as an executor, do you have to serve? And the answer to that question is no. You can just say, I decline to serve. I don't want this job. Thank you very much. And then we look down to see who was the first alternate nominated executor or the second alternate. And finally, California law will say, well, if nobody's named, here's who we'll appoint as an administrator with the will annexed. And all that means is, again, someone standing in the same shoes as an executor. As to what consideration should I take into account before making the decision to accept, I always like to tell my executors, personal representatives, that they are a fiduciary. And what that means is you're managing somebody else's estate, and you have duties of the highest level under California law to various heirs and beneficiaries. If you make a mistake, you're a target, which means you may get sued for not following either the law or for not discharging your duties and responsibilities appropriately. So before you take on the job, we always suggest discuss what that job entails, how much of a time commitment is going to be necessary, and over what period of time before you accept it. Because the compensation may not be sufficient for the potential exposure and liability that you're undertaking.
Yeah. One thing I was thinking about as you were talking is, a big part of this really is relationships. And so I would think that a big consideration is do the people in the family seem to be getting along? Because I don't know if you want to step into the role, you may not want to step into the role of referee. Maybe actually you need to get a professional involved if you have a difficult matter. There's some things that are pretty straightforward, some are not.
You raise a good point. In many families, we have dysfunctional family members, and as a result, it's going to make the administration a little more difficult. The family members may just be carrying a grudge. They may think that the executor has it in for them. We have ways of protecting that person. Typically, we'll do what are called notices of proposed action, or we'll get a court order for instructions on anything that may alter the beneficial interests just to protect the executor.
Yeah, good. What are letters testamentary or letters of administration?
When I explain this to our clients, we just call them magic papers. What it is, it's a court order that appoints the person who's been nominated generally as the executor. Those are called letters testamentary. That one-page document is certified by the court, and it opens up bank accounts. It gives you access to a decedent stock brokerage account, accounts at any financial institution. It's your paper for the world to see that you are in charge of this estate. you can collect the assets. So when we get a certified copy of those letters, that's your authority to act. Letters of administration are the same thing, but instead of acting under a will, you're acting under an intestate estate. You have the same authority, but there is no will, and you're just still collecting the assets from the same institutions.
Great. What's the significance of the death certificate?
Death certificates are issued by the county where the decedent died, and obviously it shows that this person is no longer alive. It is oftentimes required to be provided to various state organizations post-death. It's attached to tax returns frequently. So we will need a certified copy of the death certificate to transfer joint tenancy property, to collect some assets to indeed show that the decedent is passed on and that the executor or the successor in interest is entitled to collect the asset.
Yeah. So one thing to just mention as a tip, I guess you would say, for a person who's acting as an executor is you usually want to get a number of copies of the death certificate, because you're giving it for, you have to send it for all of these various accounts that a person may have. Now, some, if they've just got a very few, you may not need very many, but if there's some people that have like a lot of mutual funds that they've invested in and other things.
There are, to keep in mind that each death certificate is $12, I think, nowadays.
Yeah.
They're not cheap. To get 10 is $120. You may want to get just a few and show it to an institution, have them make a copy, and then get the certified copy back. So we try to judge how many we actually need before we tell our executors to order a bunch more. And they're also easy to order additional copies after the fact.
So, and that is another thing, that when you send them, you can ask for them basically to return it after they've used it.
Oh, absolutely.
Yeah.
You can ask for that certified copy back.
Yeah. What are some notice requirements for probate estates?
In a probate, the first notice is a notice to creditors that you give to all known or reasonably ascertainable creditors, and lets them know that they have a certain period of time within which to file claims. If a person was receiving any sort of Medi-Cal benefits, state Medicaid, we have to give notice of that to the Department of Health Services, and typically we just do that routinely. If any beneficiary of the estate is incarcerated, we got to give notice to the Victims Compensation Relief Fund or something of that nature. It's in the probate code. So there are a variety of notices that have to go out depending upon the circumstances of each particular case.
Right. And I guess one of the two primary are, of course, for the creditors and the beneficiaries. So the beneficiaries need to be notified, don't they?
Well, there's a notice of administration that's mailed to all heirs and beneficiaries, and all that says is that you filed a petition to be appointed executor, and that hearing is going to be held on such and such a date, and if you object to that, you better show up in court.
Okay. So how long does this probate process usually take?
On average, I'm going to say 6 to 9 months in 70% of the cases. They're not complex. We collect the assets, we distribute the estates. There will be an occasional estate that has litigation involved, that has complex assets, sales of businesses, things of that nature that may require a federal estate tax return. Those estates we tend to keep open because of the complexity involved a little bit longer. 90% of all estates are generally completed within a year to a year and a half. There are still occasionally estates, particularly with litigation, that may take years to resolve. That doesn't mean we can't do preliminary distributions pending the outcome of the litigation.
Right.
But in terms of, on average, 6 to 9 months is a fair guess for the vast majority of probates.
So when we're talking about litigation, we may have an unhappy creditor, we may have an unhappy beneficiary, or an omitted beneficiary, if you will. So,
there are a variety of different litigation strategies involved in probate. The most common ones are a will contest. You're challenging whether or not this was the decedent's final intentions, whether he or she was unduly influenced to write the will in a certain way, whether he or she had sufficient mental capacity to know what they owned and to who they were leaving their property. That's just one aspect of some litigation that can take months and months, if not years, to resolve.
Okay. All right. Now, for my personal accounting, I usually just write like total deposits down on my checkbook. Some people don't even keep a checkbook. Is that okay for an estate? What records and documents need to be kept?
You're a fiduciary, and as I indicated, you have duties and responsibilities to the heirs and beneficiaries, and as a result, you must keep records. And in fact, what we advise our fiduciaries is that you have to keep a record of every penny that comes in and every penny that goes out. Now, sometimes the heirs and beneficiaries may very well waive a requirement of an accounting, but if they don't all waive, you as a fiduciary have a requirement to produce in court an accounting of what you started with, what you received during the period of administration and from what source, what you expended funds on, and what's left in this estate, both cash and non-cash assets. These accountings, these probate accountings, have to be approved by the court. So it's if you don't keep a checkbook, you will probate administration.
Yeah, you better. So I tell people, and I'm sure, and I know that you do for your instructions, is basically it's a good idea to make copies of all of the checks when you're making a deposit.
Oh, absolutely.
Yeah.
So there, even though you might bunch some dividend checks and rent checks and things like that together, photocopy all those deposits.
Right, and then you should be sure that the bank is giving you the check copies. You only have access on the internet for a short time, and it's a real hassle to print them all out. So, and the judge may want, I think they want to see them, don't they?
Well, not in all cases. Only if the accounting is contested, and
Okay.
then you have a duty to prove the expenditure and what you spent it on. So if you don't keep the invoices and the records, you're going to have a difficult burden of proof to meet in terms of how did you expend the funds.
Okay. Bob, we're about out of time. Maybe you have just like a final thought you'd like to throw out. Well, actually, just have a minute. So,
Well, my final thought is a lot of frustration and expense and time can be saved with proper planning. Many clients are unwilling to do that, and that unwillingness really translates to a greater burden on the people you leave behind. So spend a few minutes really thinking about it, consulting with qualified individuals to assist them in planning the estate. If you do that, your family will be most grateful.
great. Bob, thanks so much for joining me. It's a pleasure having you as a guest. Folks, I hope that we've given you some food for thought and also maybe some motivation to go ahead and do some estate planning so that actually you can help your family to avoid this probate process. And again, we'll have another program. We'll talk about duties of a trustee. So we'll see you next time on Financial Insider Weekly.